Good afternoon. So we've reached the climax of the conference of this weekend, and you know, I think it's safe to say that we didn't lose any momentum. So it's my great pleasure to introduce Laurie Levenson of Loyola Law School, Martin Pritikin of Whittier Law School, and Dean Ken Starr of Pepperdine Law School, discussing the death penalty.
Thank you, Eyal. And since this is a closing gathering, join me in saying, Eyal, you have worked so hard. Show your thanks, if you would, by putting those hands together. And to the Pepperdine chapter of the Jewish Law Students Association, we're honored again to have guests here. Alan, we're delighted you're still here. And how about another round of applause for Alan Dershowitz? At least 30 years ago, there were few subjects in the United States that were more divisive than capital punishment, and there's a lot of conversation about it. In more recent years, there's not been, by my lights, enough conversation about it. So we're here to renew and carry on the conversation from three different perspectives, and we will begin with Marty, who will provide a biblical examination overview, theological examination, if you will, of society's ultimate sanction. And then our friend and occasional visitor at Pepperdine, we claim Laurie Levenson as a Pepperdine cousin. We'd like her to be a more closely connected member of our family. That's an applause line.
It's a lovely family.
And then I want to reflect just ever so briefly on the state of capital punishment in the United States and to suggest perhaps a process concern or two from the perspective of a non-abolitionist, but nonetheless someone who's deeply vexed by the administration of the death penalty in the United States. So with that, Marty, thank you for being here.
Thank you very much. It's a pleasure and honor to be on a panel with two illustrious scholars. Sort of feel like the new kid opening for the headliners, but hopefully I can give you guys an interesting and informative perspective. So I'm here to talk about the Jewish law perspective on the death penalty. I don't mean modern Israeli law. I mean biblical law as expounded through the Talmud primarily. And I'm not going to go through basis of biblical exegesis, but I'm just going to kind of dive right in, hopefully have a little bit of a background with it. So my assumption is, when I'm talking about the biblical perspective on the death penalty, my assumption is, in a sense, that the default assumption of the audience, if you don't have a familiarity with Jewish law, is that Jewish law is very much pro-death penalty. Because when people hear the phrase Old Testament justice, what they think is harsh retribution. In fact, if there's one phrase that people associate with the phrase Old Testament justice, it's usually eye for an eye. Right? That is a passage from the Torah. It appears in several different places. But in fact, if you look at the way the sages in the Talmud expound on the phrase eye for an eye, it has never been held to mean literal maiming of the offender. It has always referred only to compensation, the value of an eye for an eye. And there's various textual reasons, and there's various sort of policy or logical reasons, and that gets fleshed out in the Talmud. So eye for an eye is not advocating literal maiming, literal sort of tit for tat, the way people often think that it does, and people are surprised to hear that. It seems pretty plain on its face. Wouldn't seem like it's open to debate. Seems like it's pretty literal, but in fact, it's never been interpreted that way in Jewish law. But the Torah doesn't just say eye for eye; it also says life for life. And it says that in several different places as well. In fact, in some places it's much more explicit, and it says if a man takes another man's life, he shall surely be put to death. So there is provision in the Torah for the death penalty. In fact, not only is there room for the death penalty, but when someone is subject to the death penalty, the Torah apparently makes it mandatory that you must impose a death penalty. It says you shall not accept a ransom for the killer's blood, meaning that you can't, even if the victim's family, let's say, was willing to say, you know what, I don't want to see the guy put to death, sort of like a civil wrongful death suit, we'll take $1 million or whatever it is, and that'll be punishment enough for him. The Torah says no. if all the prerequisites are met and he's subject to the death penalty, he has to be put to death. Not only that, but in America, at least the way the Supreme Court currently interprets it, the only crime for which someone can be put to death is murder, not rape, not any, so to speak, lesser crime. But in the Torah, there are 36 different crimes which carry with them the death penalty. Not only murder, but various sexual offenses like incest, idol worship, even cursing or striking one's parents can subject one to the death penalty. Not only that, I'm basically building the case up against myself, right? But the methods by which the death penalty were carried out, if they were carried out, are pretty gruesome, right? We have debates in this country, there's different jurisdictions use lethal injection, or whatever, electric chair, right? Well, in Jewish law, there was 4 methods. There was decapitation, strangulation, burning, and probably one people are most familiar with, stoning. So when I tell you this, it sounds like I'm actually confirming what your preconceived notions might have been, that yes, the Jewish law very much favors the death penalty, is very much focused on retribution and, harsh and sometimes brutal retribution. However, that's only one small piece of the puzzle. Because, in fact, if you look at the totality of Jewish law, not just, what crimes are on the books, so to speak, or what sentences are on the books, but if you look at how it fit within the larger context of the judicial system, the criminal justice system, you see that Jewish law reflects a striking reluctance to apply the death penalty. Because although, as I mentioned, the Torah lists numerous instances or numerous crimes where the death penalty can be carried out, in fact, there were so many evidentiary and procedural limitations on it actually being implemented that it rendered capital punishment an extreme rarity. So to give you some examples of this, right? For a court, a Jewish judicial court, to execute a defendant, so first of all, 2 competent witnesses had to have both eyewitnessed the crime, right? Had to have warned him immediately before he committed the crime that what he did would carry with it the death penalty. The offender had to verbally acknowledge this warning and say he was going ahead with it anyway, and then go ahead and proceed with the crime. And then at the trial itself, confessions weren't allowed, circumstantial evidence not allowed, meaning if the witnesses see A chase B around a corner, and then 5 seconds later they run around the corner and they see B lying with a knife in his back in a pool of blood, it's not good enough. They weren't eyewitnesses to the crime. Right? So circumstantial evidence is not allowed. Confessions, no matter how voluntary, are not allowed. The witnesses are subject to extensive sequestered judicial interrogation, cross-examination, and if there were discrepancies between their testimony, even what we might consider relatively minor discrepancies, then their testimony could be excluded and therefore insufficient to render a conviction. Now, there were other procedural safeguards in terms of how trials occurred and in terms of how the judges render their decisions. Right? So capital cases were tried by a court of 23 judges, right? Judges who had to be well known for the integrity and compassion. Financial matters can be judged by fewer judges, 3, but capital had to be 23. Younger judges rendered their votes first, so as not to be intimidated, basically, by the older, more experienced judges. Perhaps what's happening to me now. And so that, because if a more senior judge went first and said, I vote for conviction, then the younger judge might be intimidated and afraid to say, I vote for acquittal. But if he goes first, he can, sort of rest assured that his voice will be heard. He doesn't have to worry about that. Once a judge announced that he would convict, he could change his mind and later go to acquittal, because there had to be a majority, 12 out of the 23, before you could have a conviction. But once a judge voted to acquit, he couldn't change his mind. Little remnant of double jeopardy. And the judges could acquit after a single day, but in order to convict, they had to deliberate overnight, right? Sort of an allusion to the idea that if it's a really serious decision, you got to sleep on it. Right? And then even after conviction, Jewish law required court officials to create numerous opportunities for a judge, third parties, or even the defendant himself to offer additional legal or factual grounds for an acquittal. And then conversely, erroneous acquittals were generally not subject to challenge, again, like double jeopardy. Right? So extensive were all the evidentiary, procedural, judicial limitations to a judicially implemented capital punishment that there's a famous dispute. There's a Mishnah in Makos, which says, it's Mishnah 110, for those of you who are familiar with it. Basically, the Tanakama, the anonymous author of the Mishnah, says that a bloody Sanhedrin, a bloody high court, or murderous high court, is one that would carry out one execution every 7 years. But of course, as we've heard, right, with anything, 2 Jews, 3 opinions, right, there's multiple opinions in the Mishnah about this. So Rabbi Eliezer ben Azariah says, no, a bloody high court is one that executed one person every 70 years. So that's the main debate. Is it once every 7 years or once every 70 years? To the extent that this is a famous Mishnah, that's usually what gets quoted. There's actually 2 other pieces to it. Rabbi Tarfon and Rabbi Akiva say if it were up to them, no one would ever be executed. They would always find some technicality, some way to avoid implementing it. And finally, Rabbi Shimon ben Gamliel responds to Rabbi Tarfon and Akiva and says, well, if we adopt your view, then murderers are going to run free. There's going to be bloodshed in the land because essentially there's going to be no deterrence. Right? So it's interesting that Famous Mishnah actually reflects a lot of different opinions. It's not purely abolish it altogether. But everyone has its own level of sensitivity to trying to limit it. And at the very least, I think a safe conclusion you can say is that Jewish biblical law reflects a much greater reluctance to actually carry out the death penalty than what we have in America today. To give an example of this, it's estimated that the Jewish population of ancient Israel was around 3 million people. Right? By comparison, today in America, there's about 300 million people. So it's about a 100-to-1 ratio. So if you do a little thought experiment, right, this Mishnah that talks about killing one person every 7 years or one person every 70 years, well, if you multiply that by 100 to correlate to the modern population, you're talking about killing 100 people every 70 years versus 100 people every 70 years, which translates to annually either executing 14 people a year or 1.4 people a year. Well, in the roughly 30-odd years since the Supreme Court reversed its reversal and said that executions could go forward, a little over 1,000 people have been executed, which translates to roughly 35 people a year. So if you want to try and go apples to apples, and I realize I'm making certain assumptions, right, but just to sort of give you a ballpark, this Mishnah that talks about what constitutes a murderous high court was basically saying that you're a murderous high court if you're executing people either 40% as much or 4% as much as what we're doing in America today. So if that was murderous, who knows what they would say about what's going on here today. Right? So what I've tried to do is I've tried to dissuade you from the notion that biblical law is harsh, retribution-oriented, bloodthirsty, and barbaric. However, I've actually sort of created another conundrum for myself because now that I've told you about all these evidentiary, procedural limitations in actually carrying out the death penalty, well, then it raises a question not why is biblical law so harsh, but why isn't it harsh enough? Because arguably, these various limitations, although they may go a long way to making sure that the innocent don't get executed, also make it virtually impossible for the factually guilty to get executed. So what's going on here? So one possible explanation is that Judaism has the death penalty on the books, so to speak, not because it wanted to be carried out, but because it wanted to send a message, right? One of the functions of criminal law is communicative, right? It's to express a message about what society, what the collective judgment of society is, what they condemn, what they find morally reprehensible. So even though capital punishment wouldn't necessarily be carried out, perhaps by saying these types of crimes are worthy of death, right, we send a certain message, maintain a certain moral standard. Another idea is that the rabbis may have understood that general deterrence only works if you're willing to use the death penalty frequently enough. And in fact, there was a paper that came out a few years ago, I think, that tried to study the effectiveness of the death penalty in various jurisdictions and found, essentially, that the death penalty only actually deters other people from committing murders when you use it as often as Texas does. And so maybe if you don't want to use the death penalty as often as Texas, maybe best that it barely ever gets used at all. Another idea is that given the fallibility of human fact finders, the risk of an erroneous conviction is so great that we're just not willing to countenance it. And of course, it's arguably a little easier to go that way in Jewish law, because in Jewish law, of course, God is the ultimate backstop. If the human courts don't get it right, well, there will be divine justice in the end, maybe even if only in the afterlife. Obviously, a secular legal system can't rely on a principle like that, but in Jewish law, it wasn't just a nice idea. I mean, it was obviously a real concept, that was a real punishment. There's even a punishment in Jewish law called charis, which is known as sort of a spiritual cutting off. And that was taken very seriously by people. It wasn't just a throwaway. That was a very serious problem. Another set of explanations posits that Jewish law could be so restrictive about how and when the death penalty was used, not because they were so concerned about executions occurring, but because they knew that Jewish law itself really wasn't going to carry the day. What I mean by that is this, is that there is place within halakha, within Jewish law, for a dual track, essentially, a second track system of courts. And the second track, aside from the rabbinic courts, was the king's courts. The king's courts essentially had authority to execute people without all of the same procedural safeguards as under the rabbinical courts, and all the same evidentiary limitations. It wasn't wild abandon. There still had to be at least one eyewitness. There were still limitations on circumstantial evidence and whatnot. But they had more flexibility and were given authority essentially to keep the peace, that if there's a dangerous killer out there and it's going to wreak havoc in society, that the king's courts could say, look, even though it doesn't meet every single letter of the law, or maybe there are minor contradictions between the witnesses, we can still put the person to death because we know as a factual matter he's guilty and society needs to be keep him safe. Now, we don't have empirical evidence. We don't know. We have the Mishnah. We have the medieval codes from the Rambam, right, others. We have the textual sources say what the rules were supposed to be. How often were they carried out? Who's to say? We don't really know. But the sources we do have, the oldest sources, the most trusted sources, say that there was extreme reluctance to carry out the death penalty. And to just give a brief analogy to modern life, two quick examples. One, Todd Willingham. I don't know how many of you guys are familiar with the name. Executed in Texas, I think maybe 8 years ago. Essentially, emerges in the middle of the night from a burning, his home was on fire, his 2 young daughters, he wasn't able to get out of the house, and essentially very quickly the folks in the investigation turned on him. They said it was arson. They had arson experts testify at his trial that based on burn patterns and things like that it was definitely arson, wasn't natural causes, wasn't an accident, and he was convicted largely on the basis of that expert testimony and sentenced to death. Protested his innocence. Years go on, and essentially, now that he's been executed, or even towards the end, but he didn't prevail, they basically had real experts on arson who actually did empirical testing on what, they actually burnt down buildings intentionally with different methods to see what it looked like. And they said those arson experts that testified at his trial were basically using old wives' tales about what fire evidence and arson evidence looks like. But unfortunately, they weren't able to prevail, and he was put to death. And some death penalty opponents use that example as a case of, here's a guy that we think we have good evidence, an actually factually innocent person who was executed. And of course, if that's the case, it's an unbelievable tragedy. On the other hand, there's the case of Troy Kell. Troy Kell was the subject of a documentary called Gladiator Days, Anatomy of a Prison Murder. And Troy Kell was sentenced to prison when I think he was maybe 17 or 19, shot a guy in the face because the guy was harassing Mr. Kell's female friend, shot him in the face, killed him in cold blood, and then while he was in prison serving a life sentence, he got associated with some white supremacist groups, and he and a friend held down an African-American inmate, and while his friend held him down, he stabbed him 67 times. And the entire thing was caught on videotape. Now, why the guards didn't rush in and stop it is a separate question, right? But the entire thing was caught on videotape, and him raising his arms in the air, shouting in celebration after he did it, was also caught on videotape. He has been sentenced to die. His appeals process is still ongoing. Now, I raise these two counterexamples to illustrate what I think, not for me to say, but what I think is the line that Jewish law is trying to strike, which is that we have to be very, very, very careful about executing someone who's factually innocent. Right? Obviously, there's DNA evidence, which has vindicated dozens or perhaps hundreds of people who've been on death row. And there are people who have been put to death, in all likelihood, who were factually innocent, who knows how many. And it is a horrible, unbelievable tragedy. On the other hand, right, Jewish law wouldn't go so far as to say, well, the entire death penalty should be abolished. The circumstances under which are implemented perhaps should be very, very, very narrowly constricted. But there is evil, and there is wrongdoing, and there are certain crimes and certain criminals which are so evil that there is no punishment that would be sufficient forget deterrence, from a retributive standpoint. There are some crimes that are so heinous that the person deserves to die and the system needs to put them to death, but only where the evidence is crystal, crystal, crystal clear. So it's an ancient system. It's not in effect these days. There's no temple standing in Israel. There's no Sanhedrin, right? So it's all academic in a sense anyway. But there are prosecutors today in America who quote the Old Testament when trying to sentence people to death. And so it still has applicability in that sense at the very least. And so it's important that we have a true understanding, right? And obviously, different traditions, it's a text that's open to interpretation, right? The Jewish tradition is not the only tradition to interpret this text, but we would think that since it is an originalist tradition, which hopefully, conservatives, that would appeal to them, that it be given some persuasive weight. And that originalist tradition is that although there is a death penalty, and although it does have a role, in practice, it must be extremely limited. So hopefully that's given you guys an eye-opening perspective on the biblical view on the death penalty.
Yashikah. That was terrific. My name's Laurie Levenson. I want to give somewhat of a more modern perspective on the death penalty, and I do so from the perspective of having been a former prosecutor, including a prosecutor who handled prison murder cases, from being a Jew, and being somebody who's lived long enough and practiced long enough to know that the criminal justice system makes mistakes. It makes them all the time and doesn't even necessarily realize when they've made them. The final thing I want to say about my perspective is I never wanted to play God. And I think that there's a difference between being a prosecutor, even a judge, and playing God. So as that informs my comments to you today about the death penalty in the American criminal justice system, so be it. First of all, as Professor Pritikin mentioned, we don't live in the days of the great Sanhedrin anymore. And I think most of us would agree that the jurors who are making these decisions aren't great chachams either. If you don't know that legal term, that means the wise men, the wise women. In fact, we don't have all the procedural protections that the Torah talks about, the Talmud talks about. We don't have the two-witness rule. We don't have the eyewitness. We allow the circumstantial evidence. We use snitches all the time. We have many flaws in the way these cases are prosecuted, and we know that we've made many mistakes. So exactly how many have we made? I'm not sure anyone knows, but certainly dozens of people have predicted to have been executed who actually were factually innocent of their crimes. We do know that on just the DNA exonerations, these are post-conviction DNA exonerations, I believe the number's up close to about 260 now, maybe slightly more. Now that, of course, is only the tip of the iceberg, because most crimes, contrary to what television teaches you, do not have DNA evidence, right? Use a gun, you're not going to have the DNA evidence. So it's only when they actually have the DNA evidence that they realize that they have a wrongful conviction. If you take that as the tip of the iceberg, we know that there are many more people who are sitting in prison, even sitting on death row, who are factually innocent of the crime. We also know that the politicians actually know this. Governor Ryan, some years ago, he was the governor of Illinois. He since has been convicted of his own crimes, but those involve fraud. He did do something very important before that backslide, which was he put a moratorium on the Illinois death penalty, on the executions, when he realized that 50% of the people on his death row probably had credible claims on their habeas corpus petitions. So when you have 50% error rate or the like, you got a problem. Some of the problems regarding the death penalty. Identification, witness identification. We know that eyewitnesses really believe what they say. but they often get it wrong. They get it wrong for so many reasons. It's a traumatic experience. Police, when they interact with them, reinforce the identifications they would want them to make. They look for corroborating evidence, and as was once famously said in a trial, there is a rush to judgment, often in these cases. We also know that there's a problem with racial disparity. It is the big elephant in the room. And we've known this for a while, that it's not so much, frankly, the color of the defendant's skin, although more than 50% of the people on our death rows are people of color, which is highly disproportionate to what the population is. But we know that the statistics show that if a defendant kills a white victim, they're 4 times more likely to get the death penalty than if they kill a person of color. Geographical disparity. It's up to each jurisdiction to decide whether to seek the death penalty. For example, in LA, we actually don't seek the death penalty that much, but we got a lot of murder cases, so it sort of evens out. But if you go out to some of Riverside or other jurisdictions, Yolo County, heaven forbid, you even rob a liquor store owner and shoot them during that robbery, you will face the death penalty. So if you care about sort of disparity in the system, we know that's built in. False confessions. Jewish law, as was mentioned, doesn't allow confessions. It was actually seen as a form of suicide. If you confess, you are bringing the death penalty upon yourself. And we should be very wary as well, because I always wondered, why would somebody confess to a murder they didn't commit? Until I met a young man, a Hispanic from Texas, who at 18 years old was picked up for a murder. And he didn't do it. But he ended up confessing because they said that if not, they were going to find a way to implicate his mother. And he believed, albeit naively, that he had to save his mother. We've made some movement in that the Supreme Court has said that we will no longer execute juveniles and those who are deemed mentally retarded. That's an IQ very low, 70 or below. But we still know that there are an awful lot of people who will confess because they want to be famous, because they don't know how not to, because they want to please the law enforcement officers. What other problems do we have? Or, is there anything going right? Well, no, there are a lot of other problems. I'd say ineffective assistance of counsel, what the defense lawyers can and are doing in these cases. Now, that's uneven as well. I think that many of the lawyers who do these cases are extremely dedicated, and they're working very hard and doing the best they can with the resources they have. But woe be to you if you end up in Alabama charged in a death penalty case, because your lawyer will be paid something around $2,000, which is, in the legal terms, bupkis, to handle your case. And then you're in real trouble, because on the appellate system, we've put on some limitations through what we call ADPA, the various habeas corpus laws that you can collaterally challenge. So if you don't have a good lawyer the first time around, it's going to be a very steep hill to climb if you want to attack your conviction later. These wrongful convictions, in my mind, cannot be ignored. And the question is, well, all right, we know there are problems, but isn't there still a basic value in seeking the death penalty? Which is a question that Professor Pritikin raised. And that actually raises the deeper questions. Let's think about why, in our society, we might seek the death penalty. Deterrence. I don't believe that anybody who actually works in this system thinks the death penalty is a deterrent. Or maybe there's one or two, but I tend not to believe them. And why do we say that? Well, a lot of these crimes are done by people who have perverse motivations. Sometimes they will actually commit a crime that'll get them in the headlines. There's a famous case of a gentleman who was in prison. When he was in prison, he was asked to fix the electric chair. And he was very proud of the work he did. He fixed the electric chair. He, as a benefit, was paroled shortly thereafter. And what did he do? He went out and committed another murder, so that he was executed in the very electric chair that he had perfected. A heck of a deterrent for him, right? I don't want to say the death penalty is not a deterrent. I just don't know that we have the proof that it is. And certainly not enough proof to base a system, a cause, on that. Incapacitation. Well, we have to execute them because, frankly, we want their gene pools to die out. These are the bad seed, the evil. Make them go away. I don't know that we need to do that. As I mentioned before, I did prison murder cases. Now, these were people in prison who, you'd say we don't want them near anyone. And almost always, I would say actually every case I handled, the murder happened because someone in the correctional system messed up. They did allow the defendant to be next to the informant against him. They did not intervene when they saw something happening. So we have alternatives. We have places like Pelican Bay, which are, frankly, a slow death penalty. You'll just die in prison. But we don't have to pull the trigger. The death penalty is enormously expensive. It costs, and the public I don't think recognizes this, it costs much more to execute somebody than to keep them in prison for a lifetime. And there are reasons for that. One is that they're going to get 2 sets of lawyers throughout the process. And I hear people say, well, why don't we just cut back on that? We'll save an expense. You can't. If you want to get it right, you can't cut back on the procedural protections. It's very, very expensive monetarily to have a death penalty. And you wonder, what could that money go for in our criminal justice system and in society and education as a whole if we didn't use it that way? Another part of the hoax on the American public is the delay. So here in California, where we have a death penalty on the books, but we are not executing people. We're in a moratorium right now when it comes to how we would even do it, whether we have a lawful lethal injection protocol. We have something like 50 people sitting on death row who have been there more than 25 years. You are much more likely to die on death row from natural causes than you are from execution. More than 50% of the inmates on the California death row do not have lawyers. And here's an amazing statistic. 70% of them have meritorious habeas corpus actions. That doesn't mean that they were innocent. I grant you that. But it does mean that something was not fair at their trial, that they should have a new penalty phase or a new trial altogether. So that when we look for, swift judgment, a judgment even in the same generation of when the crime occurred, not likely to happen. In Texas, yes. Elsewhere, no. Well, then it really might come down to retribution. The eye for an eye, the tooth for the tooth, the life for the life. Lots of ways to look at that. We all know if you take somebody's life, you're not bringing back the life that you took. We also know many cases where victims' families don't want the death penalty, and they don't get the final say. In listening to victims' families, and I have done so, what they overwhelmingly want is closure. They want to know that whatever justice will be, you will do it quickly, and you will let them get on with their lives. And this is something, frankly, with our system, we deprive them of more than anything. Retribution means we are willing to play God. We are willing to say that we are as knowing as the great Sanhedrin, and that we can follow all the rules and make a decision that can never be reversed. And then there's the final issue of international standards. By having the death penalty, we hold ourselves out with those great countries as Iraq, Iran, China. I realize Israel has a death penalty, but as you all know, used only once for the Eichmann case. We don't really hold ourselves out as a bastion of evolving standards of decency. And the reason I mention that phrase is that the death penalty under our American jurisprudence is part of the Eighth Amendment. And the Eighth Amendment is the only, I think, amendment where the Supreme Court continuously says it's not as the framers envisioned it to be. It is an evolving standard of decency. So where does that leave us? Well, we have choices to make. For example, some people would say, well, at least the terrorists. Let's get the death penalty against the terrorists. In fact, I heard Vice President Biden talking about that today. And I have two thoughts on it. One, jurors are actually less inclined to give the death penalty now, more than ever. And the proof of that was Zacharias Moussaoui, who was held out to be the 20th hijacker in 9/11, a horrible, horrible event. He had a jury trial. They didn't give him the death penalty. If you do give the death penalty, you have to be prepared to have these people be held out as martyrs. You're giving something to them in death that they could never have in life. The idea of who's evil, it's a very hard question to answer. So where does that leave me? I'm not an absolutist. My husband is. If my husband were sitting here, he'd have it easy. He'd tell you, never, ever, ever use the death penalty. It's a little harder for me because I do think there's the exception to every rule. You know, Woody Allen has the exception to the First Amendment, right? He says the First Amendment's great for most people. Bricks and bats are good for Nazis. For me, it's almost a similar rule. I can't tell you that I would never seek the death penalty. If, God forbid, you had Goering, you had Hitler, you had Eichmann, I could pull the switch. I could seek the death penalty. But that is not what we're doing with the death penalty today. We are using it on defendants who are wrong in what they do. They cause tremendous pain and grief. They're idiots, by and large, when they go into a liquor store and shoot the owner. And that family, I know, won't recover. But I don't think that's the case, that either the Torah, the Talmud, the Great Sanhedrin, or even myself had in mind when you think of the death penalty. Those are my thoughts.
It's always good to, from an introspective look at one's motives, to say, here's what I think is going on before I put a perspective before you. And here's what I think is going on in my own mind. I'm not an abolitionist, but I'm deeply troubled by the death penalty for reasons that have been well articulated here, and I would embrace every single criticism that has been leveled by Laurie in particular. And part of that is from a religious perspective. In contrast to the elegance of Jewish law, and I realize there are a lot of rabbinical commentators and get how many opinions with two rabbis and so forth, but still there is a coherence to Jewish law. In contrast, the world of Christian thought is so disparate once one moves beyond the hierarchical church. And I come from a non-hierarchical tradition, and so I have the greatest respect for the traditional Catholic and Orthodox perspective, which is the dignity of life means all life is to be protected. All life is to be shielded, and no one is beyond the redemptive power of being reclaimed and restored to his or her humanity. That sentiment, which has long prevailed in the Catholic and Orthodox world, has seeped, surprisingly, I think, to non-Christians into evangelical thought, so that there is an enormous amount of evangelical angst with respect to the death penalty on grounds of the dignity of all life. And I'm very torn when I read from thoughtful observers from a Christian perspective who then point to the text and say, where in the text of the New Testament do you see one word suggesting that the death penalty is appropriate under any circumstances? And the answer is there's none. No textual basis whatsoever. In fact, almost to the contrary, when, according to the Gospels, capital punishment was being carried out, Jesus said, let he who is without sin cast the first stone. A sense of forgiveness. We all fall short of the standards. So that's one dimension. But perhaps it is sort of theological, since we gather here under the auspices of the Jewish law students, that a Christian perspective would be one not only of the possibility of redemption and the dignity of all life, but also the fallibility of humanity. And what both Marty and Laurie have pointed to, which I would share with you as students, is just be, as good lawyers, as future lawyers, be very skeptical, I hope not cynical, but to be very skeptical about the process that yields up a punishment, especially one as drastic as we would all agree upon is the death penalty. And so I do, in my pro bono capacity, and have for a number of years, death penalty related work. I've worked with the Innocence Project, and I do that as a non-abolitionist. And I tell my abolitionist friends in the Innocence Project, you need some folk like us who have not come all the way over to the abolitionist perspective, and I don't think I will come over to the abolitionist perspective, and perhaps that's just another one of my moral flaws. And that brings me then to a more practical point, which really picks up also with what Laurie was saying in terms of geographic disparity, because I'd now like to introduce the structural dimension of our federal system. The Congress of the United States in Congress assembled, and it was the vision at the founding that we would have a very responsive, politically sensitive House of Representatives, then a considerably removed, right, United States Senate, elected for that first century plus by state legislatures, and then, of course, one of the progressive era reforms was, hey, what's this? Let's elect the senators ourselves, and so the 17th Amendment comes into being in the early part of the 20th century. So it was not always the case, as we know from civics. I hope we all know that from civics, that senators have always been elected by the electors of the state. Moreover, we've been very sensitive to expanding the franchise, and yes, it took constitutional amendments to do that. The 15th Amendment, women, welcome to the franchise. Can you imagine? It took again into the 20th century for there to be a federal constitutional amendment to assure women the right to vote. And of course, it took the Vietnam War, perhaps, for us to guarantee to 18-year-olds the right to vote. But we do have a Congress, and a Congress that elects, that consists of Democrats, it consists of Republicans, a few independents. And by overwhelming margins, the Congress of the United States has seen fit to have a death penalty. So it's not just Alabama nor California which has the death penalty by virtue of we the people through a proposition, because you see, we the people, I don't mean you, I mean we the organic collective, restored the death penalty when the Supreme Court of California in the 1970s said it's a violation for really powerful, it's a beautiful opinion by the court, because of its deprivation of the fundamental right to life and human dignity, which is irreparable. Congress has heard all these arguments and yet comes back time and time again, and I have a sheet here, and it's somewhat daunting, and therefore I'm not going to recite the numerous provisions of 18 U.S.C., that's United States Code, 21 United States Code, and 49 United States Code. Now, there are a lot of crimes that are enumerated by the Congress of the United States, and of course bicameralism, signed into law by the President. All these have been enacted with presidential approbation. Let me give you an example, and I want to come to the kind of example that Laurie was talking about, 18 U.S.C. 241, 242, 245, and 247, civil rights offenses resulting in death, racial motivation. Think of that. So it's death, that's a deliberate, premeditated, but it also is related to civil rights. Congress has said that's different than just ordinary murder. Or how about, espionage without death? That hasn't been tested yet, has it? Espionage without death resulting. I love this one. I say that only whimsically, murder of a member of Congress or a Supreme Court justice or an important executive branch official. If you're just chairman of the SEC, you're fair game. But here's one that should give us all to pause, and Laurie, in terms of her moral vision and moral compass, comes up to the edge here. Eichmann, her examples, genocide. How about that? Now, you said, oh my goodness, this is so depressing. What you're saying is that we, the people of the United States, through the representative process, have come to the view that there not only should be a death penalty, but that there should be a whole list of offenses, perhaps even 36 offenses, that occasion the death penalty. Well, I think we could quarrel perhaps about some of these, and reasonable minds could differ. Is this really wise to have the death penalty for so many offenses? But my single point here is Congress has seen fit year after year, overwhelming. This is not D's and R's and I's. This is everybody coming together and say, we will have a death penalty. But now, if that is bad news for you, then here's the good news, and then the takeaway that I would like to leave you with. There is laid out the most elaborate set of procedural steps before the death penalty can be sought, including, finally, a decision non-delegable by the Attorney General of the United States himself or herself. This is all laid out in provisions of the United States Attorney's Manual. You should know that as future practitioners. You've got a criminal case. Alan, that's a pretty important document to be familiar with, right? Laurie, you say now to the prosecutor. Now, in the United States Attorney's Manual, you say, well, why are you citing that? Because they're bound by it. They may not be obeying it, but they're bound by it. And through the U.S. Attorney's Manual, you will see this elaborate step-by-step process that even though the United States Attorney, and we're very proud that the recently confirmed United States Attorney from the Central District of California is a Pepperdine alumnus. We're very, very happy about that. But do you know what? As smart as he is, as able as he is, as respected as he is, he doesn't have the authority to seek the death penalty. He has the authority to recommend the seeking of the death penalty. And then it goes to Washington, D.C. And then you see the kinds of procedural protections that were in place, and sort of Mishnah 110 teaches that it would only be a bloody or a murderous Sanhedrin that would carry out one every 7 years or one every 70 years. My friends, the U.S. Code and the United States Attorney's Manual taken together do not achieve Mishnah 110 values, but they're moving in that direction. Now, there are not that many death penalty prosecutions in the United States by the federal government. And I don't know of any systematic complaint leveled at whoever the Attorney General is or whoever the President is that we have essentially a bloody Attorney General, or even, for that matter, a bloody United States Attorney. But even if we did, there are protections because her word is not the last word. Now, I leave you with this. It is so different in the states, including this state, and I hope you take away what Professor Levenson said. She said in Los Angeles County, there are not going to be that many death prosecutions. In San Francisco County, there are none. Why? Because the duly elected district attorney has said, I'm not going to bring a death case. Now go to what, in fact, are death counties. And you listed, I think, San Bernardino or Riverside County, so go to the Inland Empire. And I have great friends in the Inland Empire, but it's just different. The Inland Empire will, in fact, give rise to a fair number of death cases. Do you know what, you future lawyers and members of the state legislature, state senate, and governors should be aware of? There are no checks on that district attorney. None. There's no review. None. Isn't that odd? Throughout the United States, we are so decentralized in our federal system that the 37 states that have the death penalty, to my knowledge, correct me, those who, Alan and Laurie and others, Marty, I know of no comparable regime of careful approval of a death prosecution in the United States, in the federal, in the state system. And so let me then close with my reflections on my current death penalty case, which is the Michael Morales case here in California. Michael admits that he did it. There's no exoneration for him, except he should not have been death penalty eligible under the law. Why? Well, he became death penalty eligible because of a snitch, a jailhouse informant who then got a great deal and whose testimony has now been proven to be perjurious, but because of the limitations on federal habeas review and, frankly, a sort of hostile California state judiciary to these kinds of latter. He had a trial, he had an appeal, yes he did, but 8 years after, we now know the jailhouse snitch was lying. And yet we find ourselves with Michael, and I leave you with this. I was with Michael 4 days before he was to have been executed, then a stay, that the whole lethal injection litigation has unfolded. And I've been on, there's no really death row, but I have been on death row in Virginia. But in California, you just go to, but they say that this is where the condemned prisoners will meet you, so I understand what the San Quentin system is. So in meeting with Michael 4 days before his death, so the first time I met with him, he said, this has really haunted me, I'm prepared. He's very deeply religious, interestingly enough, and it was not a jailhouse conversion. Very deeply religious. He said, I'm ready to go. And when they kill me, they will be killing the old Michael. They won't be killing me. They'll be killing the old Michael. And I thought, Governor, why didn't you listen to my plea just to commute the sentence of this now law-abiding, living a constructive life within the profound limitations of San Quentin? And why don't you listen to the sentencing judge appointed by Ronald Reagan, and who wrote the most poignant 2.5-page letter, single-spaced, to the governor saying, Governor, if I knew as sentencing judge in Ventura County what I now know, I would not have accepted the jury's verdict. I would have sentenced him to life imprisonment, but I would not have condemned him to death row. My truly final point, have I said final 4 times now? My truly final point is, as you enter the citizenry, one of the things that has evaporated over the last 30 years, and perhaps it's because of the Willie Horton ad, is that governors are fearful of exercising their constitutional power, of doing justice. And to do that was really, at the founding, viewed as this is part of the executive power. We look to the king, the queen, the monarch. We look, we the people, to the person who we elected, we the people, the President of the United States, or we the people elected the governor to exercise a constitutional power. It doesn't have to be pardon. It doesn't have to be Mike Huckabee. It can just simply be, how about commuting, if there's any doubt whatsoever, commuting that death sentence to life imprisonment. So it doesn't surprise me that as those who see the system in and out come to be abolitionists, John Paul Stevens has now become a constitutional abolitionist, as Harry Blackmun did before him. And you may describe Ken as, well, you're just stubborn because aren't you an abolitionist? No, I'm not, because there's certain persons who will kill again if they're given the opportunity. I've seen them. I've talked to them. Society deserves to be protected from, and I will use the term, and I will not use, and I will say it unapologetically, evil persons who will kill again. Thank you. We are so wildly over time. You were to be dismissed at 3:30, and it's 5 till 4. Do you have time for 2 questions? Oh, Professor Dershowitz, who needs to go to the airport.
One very brief question and one very brief comment and a very sharp, though respectful question. So my comment is, of course, under Jewish law, it was very difficult formally to execute somebody, but any society that believed that somebody had actually killed and would kill again, and there was only one witness or two witnesses without a warning, remember there's no imprisonment in classic law, wouldn't let the guy go free. And so we know from Menachem Milan and other experts on Jewish law that what they did is they took the man who they knew was guilty and they put him in a locked room and they fed him only a combination of water and barley, and by accident his stomach burst and he died. I mean, that's the informal mechanism of the death penalty because they didn't want to pollute the official system, and I think one has to take into account that. Now my pointed question, I mean it respectfully, but 15 years ago I got a call asking me to take a case involving the death penalty. The state was seeking the death penalty. I was very reluctant. I originally said no, and then I got pressed, and I took the case, and then about 2 months after I took the case and was working on it, they decided not to impose the death penalty, and I stayed in the case. And Professor Levenson, who's very strongly opposed to the death penalty and said all the right words here, wrote a letter to a Jewish newspaper in which she strongly condemned me for taking the case and simply serving as a lawyer. And her exact words were, the case was not a good cause. Of course, the defendant was O.J. Simpson. But how can you reconcile your extreme criticism of me and other lawyers for simply taking a case, which was a death penalty case, because you didn't think it was a just cause? Weren't you, in fact, playing God, which you said you weren't playing? Weren't you denying the possibility that mistakes can be made? And don't you want to apologize to me for that?
I think not. I think Professor Dershowitz is one of the great lawyers of our time, and has been acknowledged as such. To be more precise, and I don't know that that's the nature of our discussion, I believe that there was some background where Professor Dershowitz had held himself out as somebody who's out there as sort of the representative of the downtrodden. And there are many downtrodden, and there are many people who deserve our representation. I had no fear that O.J. Simpson would be well represented in this matter. And I thought that maybe it would be a bit of an exaggeration to say that he needed, more so than all the other people sitting out there, to have Professor Dershowitz represent him. Now, I wouldn't condemn any defense lawyer for doing what Professor Dershowitz ably does. But I think we always have to be candid. When we choose our causes, why are we doing it? Are we doing it out of the principle? Are we doing it for the personal rewards? Are we doing it for recognition? Why are we doing it? So I'm glad I had an opportunity to clarify that for you. And I hope that everybody here does understand that you should go out and represent people. And if you happen to represent an O.J. Simpson, that's fine. But I don't think that by choosing the high-profile case, the Klaus von Bülow, the O.J. Simpson, and the like, it necessarily makes a strong statement of principle as when Dean Starr represents Michael Morales. I just don't think it does.
Don't you think you ought to add the fact that I do 55% of my cases pro bono, and that the fact is that you don't know who else I represent. I represent dozens and dozens of poor, obscure people. Dean mentioned one that I'm doing now, death row inmate. Nobody knows their names. It's in the nature of obscure cases that you don't get to know about.
I'm glad you shared that with us.
Alan, I hope you keep taking both kinds of cases. And I need you on Michael Morales because it's getting pretty, we're getting closer on Michael's case because he will be the next one to experience death in San Quentin. One more, yes.
Well, it seems to me that the consensus, even from people that are on what you call the abolitionist side or people on the pro-death penalty side, is that nobody likes it when innocent people get the death penalty. And I think even the pro-death penalty people would want to, it would be productive to find out what are the problems in the system that is resulting in that and to plug those holes if possible. That seems to me like the middle ground that's almost obvious. So what are those holes? How do you plug them?
I think that Professor Levenson identified really a whole host of them, and she started with witness identification, and Marty identified a particular case involving arson. Guess what? A lot of arson correct me, prosecutors, I'm not a prosecutor, criminal defense lawyer, but I'm pretty familiar as a non-practitioner in the system. A lot of arson prosecutions are based on junk science. Junk science. That was a junk science prosecution. And yet, when the captain of the fire community stands before the jury and says, we have, the fire marshal, and says, here's what we discovered, and this is consistent with our ordinary and customary procedures, it is taken as gospel, and yet there's literature out there, I'm using one, just picking up on arson, that it is junk science. So there's very little, you can say, well, aren't there some quality controls with respect to evidence? Yes, but it comes down to the adversary system, ineffective assistance of counsel. If you can't afford, Alan does 55% of his cases pro bono, but if you can't afford him, right, how are you going to get all that information and so forth? So the quality of the advocacy is really very poor in too many states. Right.
You know, I'm just going to jump in. I think that there's a couple of issues. One, in which we haven't talked really outright about, the politics, right? So the politicians want to win. Being hard on crime is a way to win. And in fact, when Dean Starr was reciting some of the recent federal legislation that imposed the death penalty, there are actually transcripts from the congressional hearings where the Democrats, in mockery of the Republicans, with all due respect, were yelling, kill, 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 as the debate was going on. Everybody knew what was going on during this discussion. So there's an ideological split. Some people think, rather than being nuanced and careful, and they haven't had their hand in it, they feel to be tough on crime, they've got to have the death penalty. The second thing, honestly, is resources, which is to fix what we have, and I think that Justice Blackmun was right. I don't know that we can, tinker with the machinery of death. You'd have to have a lot more money put into the defense lawyers, the experts, the court systems, all of the above. And we have no political will to do that. We have no financial will to do that.
One thing to just add, I mean, if you think about the beyond reasonable doubt standard, right? I mean, that's the standard throughout criminal law. There's no separate standard for a death case. That's still the standard, right? Well, if you think about what that standard means, I mean, from a constitutional perspective, you're not allowed to put a number on it, right? But they've done surveys about, juries say, what is your confidence level that you think meets beyond a reasonable doubt. And averages have been around the 75-80% range. I mean, if you think about it, putting a drug on the market, you think about statistical significance, right? Statistical significance is 95%. That means there's a 5% chance you're wrong. Here, 80% chance is good enough to take someone's life away. I don't know exactly what the answer is. I mean, maybe you should have a beyond all doubt standard for the sentencing phase, and maybe that would basically eliminate it for everyone but the Eichmanns. I don't know. But, given that we can't put all the resources in we would need to in order to make the death penalty work the way it's supposed to, maybe some, super majority type evidentiary standard or burden of proof, maybe that could get us towards where we want to go. I don't know.
Last word?
I'm glad we're talking about it. I think that I have to tell you, there is a conversion that goes on. And I'm sure Professor Dershowitz, this might be the only thing we would agree, which is oftentimes people sort of say, well, the prosecutors feel this way, and the defense lawyers feel this way, and the liberals and the conservatives. What you've seen with this panel today proves that that's not true, and it shouldn't be true with you either. I don't care what end of the political spectrum you're on. I don't care what religion you are. I don't care what you've done in terms of prior jobs. The death penalty is something that hits at the core of why we go into the justice system. And that's why, I would guess, as Jews, we can't stop talking about it, and we shouldn't stop talking about it.
Thank you. Would you join me in thanking Professor Pritikin and Professor Levenson?